Good morning. I regret not joining you, but it was raining cats and dogs here in San Antonio, and I didn't want to do the backstroke.
That's fine. That's right. We'll see it. It's real. DJD. Yes.
Hey,
All right, sir. Good to see you. Yes, sir. Yeah. Trying to keep it all fun. This year.
I'm promoted.
I'm South Line.
Hi, I'm Michelle Lay with the Attorney General's.
Nice to meet you. I'm the county clerk for Dallas.
Oh, okay. All right, excellent.
County, short timer, pick the right one. Short timer.
Yeah, clock is ticking on.
Short timer.
Are you retiring, Joe? I didn't run for re-election.
Oh, okay.
End of this term. December 31st, 2026, 11:59.
But who's counting?
218 or 217 days.
And many of us got
Who's
our-
keeping track, right?
What's that?
Who's keeping track?
No, I don't plan on going too far. There's a lot that I want to do, but
Yeah.
I can't do it sitting in the seat of the county clerk.
Right, right.
Yeah.
Well, great, man. That's awesome.
Mhm.
Are you gonna stay on the committee?
That's up to Frank.
I think it's up to me.
Race lights also.
Justice Simmons will be ready.
Yeah,
I'll put in a good word for you.
thank you very much. I appreciate it.
That's the only influence I have.
Is this it?
Yes. You have to open the browser. Yeah, please. Okay.
Yeah, hold on.
So that makes you.
Okay. One of our previous meetings.
Is she?
Ooh.
I.
Did you stay at the same hotel? She's.
Yeah.
Was there a Wi-Fi to use here? Oh, thank you. Yeah, JV guest.
What's the first character?
That's a one.
I tried that, but it didn't work.
18 exclamation mark. E. Home.
She's not good.
It's not correct.
Look at it real quick. Make sure.
About to be at.
y'all are kind of breaking up. I know the meeting hasn't started yet, but it's hard to hear y'all. We don't hear every word spoken.
What did you say?
I think everybody's talking very quietly. Can you hear me okay now?
Yes, sir. Thank you so much. I didn't want to complain because the meeting hadn't started, but then I didn't want to interrupt it to tell you.
Oh, no.
Ran to Emily Mexico yesterday.
Yes, because she was at another meeting.
She's got advisory from I guess.
She does.
That's why I'm supposed to be.
Ours is this afternoon. It's the last one. Yeah, this one's out.
Oh, so you're here with her late. Yeah, I heard that, we're taking us, rules about the hallucination stuff. Yeah.
Morning.
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 How's it going? Well, yeah, thank you. Good morning, how are you?
Fine.
Good morning.
All right, is here okay?
That's fine.
Thank you.
Yeah. Yeah.
Great service. 10 more years. Yes.
Yeah. Well, so we were going to do a policy, we had an admin meeting yesterday, but before we had the meeting, Emily talked about the fact that advisory was going to take it up, so we tabled ours.
Oh.
We were ready to do something, so we tabled it to see if it's gonna be redundant based on what happened today.
Yeah, stuff.
Yeah. Mhm.
We're getting more and more of it and
Birthday stuff, you might as well,
Yes.
I mean, you could bet that it's not anything privacy.
yeah, and my approach initially was to say, let them file whatever they want to file, but now it's getting,
No,
it's just a waste of time.
it's a waste of time. I mean, like, none of the propositions, I mean, the cases are, sometimes they exist, but they don't stand for the propositions, sometimes they're just flat out. Even the sites are wrong. And then trying to figure it out is.
Have y'all looked at it under like Rule 45 or?
So yesterday, we had a fairly, robust admin meeting, and one of the things we were gonna take up is that issue about that kind of a policy. Because originally, when it started, we deliberately those things just to see what we wanted to do, right? And then also to have the flexibility, because per se, obviously, different way to handle it than attorneys that are using it,
Sure.
right? And so after seeing it for this long, I thought we were ready to take up a specific policy. We tabled it because Emily wanted to go to advisory, see what they were gonna do, and that's.
And I know Emily's like on that task force or something.
She is. She is.
Yeah.
So we tabled it, see what came out of the meeting today. But
Interesting.
we are ready to move forward with something because it's eating up too much of our time in case what's going up, we don't have the bandwidth for that.
Right.
I can call her.
Give it an AI judge to handle your AI,
Yeah,
but.
less. Yeah. Like, my inclination is to strike a breed, but some of them wanna dig into it, and I'm like, okay. So we'll see.
It's one of the issues that I was looking at, all the directives do the burn for correction. Today's meeting is it merit deficiency? Is it a,
52 division 3.
is it a deficiency prevents creating fine, so slowly.
Yeah. So I think if you have them do a certification.
Yeah.
Right, that's part of, then you have more flexibility because they're certifying various things.
Yeah.
Right? And then after they file the certification, if you figure out that they're, then you
Right now,
have-
we're not a certification.
Right, so if you do the certification, then I think the second step is, then if you find a hallucination, then you have a large bandwidth of what you can do.
Yeah, I guess off the top. Rather than specific. Just to call it a certification like you would for a mandamus. To say, I certify that all the states you're gonna.
I agree. And then you dismiss it. Right,
You dismiss,
If you
you
do-
dismiss a deal.
right, if you do 52,
Right.
right, then within a certain time frame, they could have another bite at the apple. Right? And with as much of a problem as getting to be.
Justin Simmons is walking in the building, so it'll be another couple of minutes. We'll get started.
Back to that.
So that's where I'm leaning.
I don't think let's slow.
Not with, oh, well, let me see if I can get past it and then they do that and then I'll correct it.
Well, you don't call it an AI policy because I think it's, well, I didn't use AI.
No.
But you say,
It's
I just made it up.
Right.
Something like that.
And the other-
I know folks who have been on some side.
That would be an easy, non-controversial approach. You're right, the advisory committee, I think it would be easier to move through
Oh, really?
public procedure,
It's free to do.
under Rule 9 or
I
something.
think so too.
Based on extra folks.
Rule 38 might happen.
Page.
Maybe, but it may be now. Moving forward.
Well, we all have, we all decide, because we're having the same conversation. We
Yeah.
got some, like, I want to say, honey, hold on, we're not
It's useful.
Extremely.
Yeah. I'm not gonna say that it's not useful. I'm not saying that people shouldn't use it, but it's proper use, right? Like, there's a difference between proper use of medication and then popping them like candy.
Oh, right. They recently had a case involving Benadryl.
Right,
It's.
yes.
I've seen that one back and
Yes.
forth, it's been in, taking
Yes.
monthly,
Yeah,
that, our case.
one child who got, and then all the other tested positive. Yeah, whoever the Benadryl, that's why.
Was that intentional?
Yeah, it was
That's the issue of the case.
yes, they were doping the kids so they go to sleep. It was a daycare.
People, 60
Yeah.
emails of, all.
Right.
I'll learn as best I can. Oh, yeah.
Is it gross negligence? What a question, TCA was.
I think it was, it may have been gross.
Yeah, pretty easy drive, but with the time, you know, time. Yeah, traffic's not too big.
Good drive.
I only did it.
Little traffic, that's the key.
Yeah.
Yeah.
Unless they're not using it for allergies.
15.
Yes, sir.
It was awesome. It was 15.
One of these 15. Tina's with help.
Right, yeah, sorry. The colony is.
It's gonna go like, it's the same room as we were in last time. We're in the same room.
Really?
I don't know.
As last time.
If you come, next time you come to the final office, then because it's like, you know, I don't know.
Yeah,
This program.
Well, okay. In 2 towns, I think.
I mean, they could probably have it done in a quarter. But it is. Well, bus.
Yeah.
It's a little bit lunch bus there.
A week with that team.
When I stay at, in Vegas, we stay old Vegas. They built that new IHOP, or not IHOP, White Castle's on.
I mean, it doesn't
Gas
matter.
station used to be right there.
Multiple counties are just us.
3 or 4 o'clock in the morning.
I don't think there's ever had our hands are like.
I think I might have once been like, in like,
I don't know,
Fremont.
room with enough.
Yeah, there's one down there. Yeah, I think I have been to
It's old Vegas.
Yeah.
I was in up at the under
It is
the strip mall,
especially
like
if
across
it's
the
not a
hospital, like I walk way up to the little indoor mall where it's like all product or something.
And different data.
Where you walk in the windows and I gag the prices. These schools are ugly too.
The chili dog on Fremont.
No, they.
That was like before I don't know.
And you don't have to delay getting out to hit inspect the aircraft.
With the.
Ready to get it out.
Runs 2 miles a day and lift every morning travel.
Nice.
Did you take any 40 minutes a day or did you take on way in or?
Drove in yesterday after mid and.
My dog's nice.
Absolutely
Yeah.
not.
Yeah.
Yeah.
So you did it young.
Yeah. Generally, I try to drive the.
Every morning. Don't even drive 2 miles a day.
So I got in a little bit later than I'd like, but.
This time last year.
Yeah.
She is from Texas and.
Those both.
That's a great day, too.
I used to like to do that.
The worst places to be.
That's better than a 5-star hotel.
It's absolutely.
Yeah, especially with Darren running around doing all this stuff.
Yes, yes, I've offered numerous times.
2.5 hours.
You can walk in right now, but.
We're gonna go have-
She's like, there's a lot of old towns. Sorry.
And then our north rest of our team, so then she'll 8:30.
At the
she could great.
competition.
You're enough, they do it a third week on it.
Oh, got it.
They like being Richards. Years.
Like after the Friday here, and then all the kids just start holding stuff, because
Yeah.
gloves are
Well,
on
if
head.
it's in Richard, then yeah. There's, she's a hub from my house, away.
They're going back up this weekend.
Yeah.
Some that so look, I gotta.
Yeah.
I love hanging out with you guys.
I know. No, it's gonna be it's gonna be a busy couple of months, and I was looking at that, so. Part of the admin.
On their first week, they're not mad.
Yeah, what, lower floor. Gotcha.
We got
Around the backyard. Just
61 transfers.
Yeah.
Another one that's like.
Good morning. I
Morning.
want to welcome everybody to our JCIT meeting. It's good to be here and thank you for accommodating me. I'm a little late, but San Antonio had some massive alert earlier in the morning saying, don't leave your house unless you're evacuating. And so anyway, put me on the road a little bit late, but traffic was great. Nobody was out. And so eventually I got here. So I apologize anyway. So for being late. So we'll start with basically our minutes from the March 2026 meeting. I don't know if everybody had a chance to kind of look at that or see those. Be basic. All right, so I have a motion to approve those minutes.
Jump forward and move to approve.
All right, and then raise your hands if everybody affirms. Affirm, okay. All right, and so those are accepted. So the minutes are accepted. We're going to start with our JCIT standards and get an update on those from Bob. No, from Frank. All right, go Frank.
Fire times, I'll take it.
Oh, okay. All right.
Bob's gonna cover me.
Okay.
So we talked about the standards version 11 last meeting, and there were a few changes then. Let me get it shared here. So we still have not formally adopted the standards through the Supreme Court. Everything, the top 3 updates highlighted in green, light blue, and yellow were approved last meeting. There have been 2 additions since then, or 2 changes. Those in red and green. The first one, as you can see, is based on a Supreme Court docket listed there. The second one I'll explain in greater detail when we get to it, but let me just scroll down so you can see the changes. So I'll start with the one in red first. It's on page 7, I believe. Any questions or concerns about that one?
Can everybody see that? Can we pull that up a little bit bigger? So everybody can see a little closer.
And then the second one,
What does that say? Just so.
foreign out of state subpoena request.
Yeah.
Wasn't that addressed in a miscellaneous order?
Yes,
Yeah.
Supreme Court order.
Yes.
It's
So we
it's just people who are putting it under civil other, and because it's a new suit charge. And so this is just to identify them easier.
And the second one is about permissions, and I'll provide a little bit of background on this one, and I'll ask Jamie and the Tyler team to correct anything I misstate or add to it, of course. In essence, the way Research Texas is configured currently, if you are a pro se filer, you can view information about cases you're a party to. If you're represented by an attorney, you cannot, even if you're a party to the case. So the proposed change here is to change Research Texas. So if you're a party to a case, you can view documents from any cases you're a party to unless they're sealed. So we'll adopt it here, and then of course, the Supreme Court will make it official, and then we'll make the configuration change and research with Tyler's assistance.
Okay, and let me just point out, there's nobody more surprised, I think, than Bob and myself that was in there. We had no idea. Of course, somebody who's a party to a case can always see everything in their case. I think that's what's going on right now in most counties. I mean, can't imagine that they're restricting a party from seeing the case, even if they're represented by counsel. So all of that to say is this is really to align with really what the rules are and kind of what we know they are. And I'm so sorry. I never even knew that was in there until it was brought to our attention. And I apologize for not being more cautious and looking at it much closer before. So this is really to rectify something that should not be there. So
Jamie, is there anything that you'd like to add?
Just the way that we're going to determine a party is based on them having an email address in the local CMS and that matching the email address that they are using to register and research. Those linked together is what determines that they are the party that they say they are. So if the local CMS does not have an email address and they go to research, they still would not be able to see the cases.
So when they sign up for research and they say, this is my email address, y'all are sending something to that email address before you give them access, correct?
Yeah, they have to activate it.
Okay. So they have to,
It's a valid email.
right, so they have to verify that that is the person that has that email address, correct?
To explain the change in the standards in a little more detail, item 5 or role 5 is a new role, party to the case. And the former role 5 is now role 6, which is other registered users.
Do we have it later on in the document? I think it says something about the matrix is for role 5. Did we change that to role 6?
I wasn't aware of that. I'll have to look at that.
It's like right below this.
Yeah, it's like the
Yeah,
Right here.
a little further.
further down, yeah. But,
Yeah,
but yes, row 5 would have to be changed to row 6.
Yeah.
And then there's a big matrix header that would have to be the same thing.
This one?
No, keep going down.
I assume this one needs to be changed too.
Correct.
There is a reference to roll 5 above.
Yeah. Look at the,
Can we just search everywhere for role 5?
right,
There it is.
yeah, so. Almost was 1. Maybe we should have made it like 4A.
Sorry, folks.
Okay.
If I change any that are wrong, let me know.
I have a quick question, if I may.
Yeah.
Was this document sent out separately? Because I didn't see it attached to the email notification that I pulled up. There might have been more than one. Yeah, that's my first question.
It was not sent out separately.
Are we able to get it into in some way?
So you mean you want, let me just back up, Mark. So you want it, basically, you're not saying what's on the screen. So is that what you want, the technology standards with the revisions on it?
Yes, ma'am. Yeah, I was hoping to have a copy of that.
Frank, would you mind emailing that to Mark?
No problem.
Okay, we're gonna do it. We'll send it to you.
Yeah.
Well, also, a follow-up question. This may be too technical to deal with right now, but does anyone know if the documents themselves could be accessed sort of with a deep link? In other words, could we have a unique link to that particular document in a case? And I'm thinking in terms of the bigger workflow here, if you know.
I don't understand your question. So could you start over again?
Yeah. Is there if we search for a document and if we pull it up on the screen, or is it still just download? Your selected documents will be downloaded. And if we pull it up on the screen, would that unique string of the URL characters, is that something we can embed in our own indexes, for example, for trial prep, etc.? And it may be not a question for today. If so, apologize.
Something for, does anybody know?
I know we're building something for like an appellate docket index.
Yeah,
along
but
those
I
lines. I think he's saying about something similar, but.
But on a trial basis level,
Yeah.
I don't think we have that now,
That's-
as
it's
far
okay.
as I know, but
That's-
it's, yeah,
But I
it sounds
thought
like
we
something that we
actually
should
Used to
do.
have that and we changed it because people were posting links to documents in Facebook forums and that kind of stuff. And so we had to change that, so you couldn't do that.
Understand. Thank you.
Let us just kind of take a action item to check into
That'd
that,
be great.
and figure out if what I'm saying is accurate, and if not, there's a reason why we couldn't do that.
And when these parties, when you say the email address must match party, you're not showing that email address anywhere in Research Texas, is that correct?
Are you planning to move or adopt these?
Yes, I was gonna talk, but I just want to know, okay, so you've gotten that question answered. So when we have email must match the party, so we've got the party and that's when they're just on their own. Is that what we're talking about? Correct. When they're represented by council, we'll also have council involved with their address as well as the party, right?
Council would be designated by the bar.
Yeah.
But does that cover the ad hoc? That's the only version that we were looking into from Judge Hine last meeting. That wouldn't cover the ad items, so that's part of the party type discussion.
Okay. So the idea that we may need to segregate out or add a specific ad litem.
Well, it's just a matter of the standards committee looking at all the party types.
Yeah.
Because that's one thing that we looked at in our subcommittee meeting. There's over, I think 1,500 unique party types in the e-filing system that needs to be condensed down to a standardized list.
So remind me, on those parties that we have listed, is that just from across the state, every designation of a party, however differently?
It's
Every county.
Every county,
Adding their
everything
own.
gone in to look and see what they're
Yeah.
doing. Yeah, now I remember us discussing this last time, so, and it's one of those things I think would be valuable, although we'll do this in a later discussion, but we ought to discuss, okay, what's the benefit of narrowing it down? It seems totally logical. This is an insult to our committee that it's gone out of control. But in the end, if that's how clerks across the state have things done and it works in their system and nobody cares, then we just need to have a broader discussion before we ramp up and, say, oh no, we're gonna have 5 party types or 10 party types or something like that. But I immediately think it needs to be rectified, but then I started thinking, I don't know, and what I would like to do is hear from everyone on how does this affect everybody.
Well, I think for one, it helps figure out when we're talking about party access,
Yeah,
then we know exactly what party means what party, right?
right.
So I think that's a big.
Rather than whoever we decide to, whoever decides to designate, whatever.
Yeah.
Yeah, no, okay. Yeah. All right, I'm sorry, Frank, if you want to go on and if there's other things that we want to
That
go
was it.
here.
That was the only change.
Okay, so that is the only change. Does anybody want to have further conversation or questions about the the change that we're making for the party, which I think is absolutely needs to be done.
Do we know when all of these changes can go up to the spring board?
The plan is this coming week, this next week.
Okay. Before they kind of go on a little summer break that they can. All right, so with that in mind, do I hear a motion to go ahead and adopt this new schedule, basically of parties that we have developed? Okay, Tracy is motioned and Bob is seconded. All in favor, say aye.
Aye.
Aye. All right, anybody opposed? Okay, what version is this now? Trying to do it.
I saw it as 11.0.
Okay. All right, great. Great work today. That was really something that we really needed to take care of in terms of what the party could see. So our next stop is trying to identify what are these parties that anybody has identified across the state. So, all right, Frank, do you want to proceed to the next?
So I believe the next is Bob's.
Yeah.
Okay, you want to do that?
Tracy just gave you an introduction to this. We have anywhere from 13 to 1,500 individual unique party types in the system. I asked Frank to get with Tyler and ask them what was their standard configuration if they were bringing up a new system or a new uniform case management system that's out there. They have 78. I've looked at the list of 78. I see there on the criminal side, there needs to be probably a couple of additions, but we're talking at the margins, nothing even approaching what we have. Having been through this before with other topics that are related to this kind of thing, everybody wants a standard as long as their items are in it. And that may be why party types has evolved the way it has evolved. So the question before us is, one, is it worth it? Because it's going to be a monumental effort. Two, if we decide to go that way, we need to bring in more, we need to get more people taking a look at this than just the standards committee or the filing committee. And we need to get folks who actively work with this level of data routinely. We probably need to get some of our EFSPs involved, because this is not going to be simple, nor is it going to be quick. But if we're going to do it, it needs to be done right. So,
And probably get OCA involved, since
Yeah.
they are trying to bring on the CADX system. And I'm assuming in that they're coming up with party types that are going to be standard for that system. And maybe from that list of party types, we can come up with what we can have in e-file taxes and research taxes.
So then Tyler, in coming up with their party types, I'm assuming you're going to collaborate with us on, or in the counties and everybody else on party types. And what is the schedule for that, what you're doing in that regard? I'm just trying to figure out how fast we need to move and get moving to give you our recommendations just from hearing from our group.
Well, we already have the 78 that Bob talked about, so we already have those defined.
Okay.
For the next step, which is the court analytics project that we're working on, I don't think that you guys will have time to accomplish it in the time that we need to start rolling that out, but there can be mapping that happens after the fact.
All right.
So I mean, we're pretty close to working on early adopters and that.
Okay, so to talk a little bit further about this, everybody kind of understands kind of what we're talking about, how this got out of control. Probably would be well to just go back and say, okay, how did we come up with so many party types? How did we come up with 150, 200 party types? How did that evolve? And my understanding is it's evolved on a kind of county by county basis that they chose and then it goes into the system. Is that correct? Okay, so.
Mr. Tyler, or any of y'all. We know that if you look at the list of the 13 to 1500, you can see, like, take Houston.
Yeah.
4 or 5 different ways of saying Houston. Or pick your label. Is there any way that we could go through and let AI or something go through and consolidate those or group all those where you know that it's the same thing? You know, district court, DC, DIST, CRT,
And then
all
that
that
becomes a
kind of
different, and that becomes the party label and it becomes a different party because they have now said,
yes, it's a new unique way of saying it. So you could have.
Okay,
So
it's just whatever you
I
like.
have the list here in front of me, so you
Yeah.
can say attorney, so one says attorney. One says attorney dash in dash fact. One says attorney not representing a party, attorney OCA, attorney participant. Just tons of different
that.
attorneys, but then later on, you can come up with ATTY.
Yeah.
And someone added ATTY analyzer. But some of them got very specific in the list because one added a party type of Bear County Sheriff's Office. And one put AUNT, AUNT. And then one put bank. I mean, it's just, people are coming up with different party types they added in that potentially does not need to be there. Or maybe coming up with a other party type or something.
Yeah, so
Something
different
been there.
counties and whoever the clerk is or whatever is just putting something in, yes.
So I can see, even if we narrow it down, like, for example, just to tie back into what we just did, if they figure out that in order to have access to the file on the Research Texas side, that they need to be listed as a party, I can see people putting in their parents who aren't parties to the offense, but the attorney doesn't want to have to update them, so that they figure out a way to put their name or an email in on the clerk side so that they can have access on the computer side. Like, I can see people doing things to proliferate
This,
access even after we clean it up. So I think there's a conversation between what we just did to give people access on the Research Texas side, and then the party side, which then will be impacted. So even after you clean this up, there is a possibility that things will proliferate because of the fact that we're giving that person in that file access to Research Texas now. Does that make sense?
okay, so if an individual has access to, and we're talking pro se maybe.
Non-pro se. So let's say that I have defendant Joe Bob, right? Joe Bob's mom is very involved, as Joe Bob's mom is always very involved.
Yeah.
And so Joe Bob has now access because we've given him access as a person,
Yeah.
right, under his attorney. But the attorney now wants John to list Joe Bob's mom because I'm tired of answering questions, and Joe Bob never knows what to answer his mom. So I can see where people are gonna start putting people into that field, right? In order to try to alleviate.
To give them, in other words, to give them access to all the documents in the case. Joe Bob's mom says he's a fool and not doing anything. I want to see everything.
Or I'm paying for it.
Or I'm paying for it, so I want to see everything. Okay, but that is clearly they're not a party. That's not where they would go. And I'm shocked that they'd be able to get into and create themselves as a party, just a random person off.
But there's
Does the system work that way?
there's an aunt in there right now. So
There's actually ones called
isn't that because
involved
the
party
district
and
clerk-
involved person.
But isn't it more because the district clerk did it?
Correct.
Right? I mean, I don't think anybody, I mean, tell me, can just a random person come in and just make themselves a party, change the style, do all that?
well, if someone gets someone to put them in under that category and create something, because right now that's clearly what they're doing.
No, I don't think, And it's no offense to district clerks or anybody else. I could see somebody just putting in a new person in the office, brand new, first day, aunt. They see it somewhere in a style of a case and they put aunt. It's a mistake. I don't think that that is really a title a lot of people are going to use. But I think it was just a mistake and unfortunately, but I'm trying to think, I just can't think of a situation where a person could come in and.
Well, technically, the person, I'm Joe Bob's mom, I could e-file.
Yeah, right.
And add
And-
myself as a party, and if the clerk didn't notice it at the time of e-filing and accepted it, I'm now a party on the case.
Now you can see the documents in the case.
Yeah, Mark, do you wanna,
What's the difference between, I mean, there's always gonna be public access.
right,
So why can't these so-called parties, other participants, I'll just label them all as participants, go to the public access and the real parties remain pristine on the other side where you're granted that type of access.
right.
But then we've got to shut down the parties part pretty closely. And if we are going to narrow it down, then there's got to be a limitation to how these grow or stay exactly as they need to be.
But at some point, do we think that if there is a need with something, maybe a bill passed or a request from the Supreme Court as it relates to defining information and the waters get really muddy because we have all these 1,500 different party types. And so I see that as being a problem.
I do too.
I was, before the meeting started, I was talking about the 2003 implementation of Odyssey in Dallas, where we had divorce. And because in the mainframe it's free form field, you can write whatever you want. And it's similar to what Bob was saying. It was eight different instances of how they used divorce. And so we had to write a script to actually narrow down, okay, all these different ways that it was split, these 8 different ways, this is what it's gonna be. And that's what we made the party type, the hard-coded party type in the case management system. I think that may be the kind of exercise we're gonna have to go through. As because 1,500, that makes absolutely no sense.
No, I
But-
totally agree.
But also, if someone needs to add something because of a particular instance, there's notes that you could put in the case management system, Enterprise Justice Now, that you can actually make a note if the judge needs to see anything. But as it relates to Joe Bob's mom, there's public access.
Yeah,
So if we narrow this down, can we keep it narrowed so that it doesn't proliferate up again?
It's like the case types.
Yeah, it's just a matter of getting it in the standards and then saying, these are the standard party types and you can't deviate.
And you can't
Yeah.
deviate.
I want to piggyback on what John said, but keep in mind that Joe Bob's mom, through research, can have access to the documents. She just has to pay for them. I think that's a differentiator between,
okay.
like, as long as they're,
Which is why we made the differentiation with parties today, right?
yes, as long as
Because-
they're not it's like if it's a sealed document or a secure document or anything like that. Because Joe Bob's mom is just coming in as public, right?
Yeah.
She's just a registered
Right.
user. So
Yeah.
she would still have access as long as it was a appropriate document type.
Right.
But if we had generic party types like participant, that everybody uses participant, not aunt or mother or father or, or whatever, then they have that option and make that mapping from their CMS and say, this party type really means participant.
It just needs to be broad enough to capture.
Mark, do you need to say something? Sorry.
No, I think we're on the right track. I also like the idea that Bob referenced of an AI narrowing of the field, so to speak, and then make room for the possibility of a process for modification if something needs to be added, etc. So, and I put a couple comments in chat.
Okay.
The follow-up question would be: do we have to have a certain AI that we're going to be using if we're going to play with this and try and create stuff? If anyone knows that.
Sensitive, is it?
It's not sensitive information, so I'm not sure that we.
Sure.
I
I mean,
think
Claude Cowork,
things to go through is,
Notebook LM would both probably have those functionalities.
yeah. Yeah, it's not yeah, this isn't hard. We're not asking for a lot of AI intellect on this one.
We OCA can produce that and then get
Thank
back
you.
to the subcommittee,
Yeah.
if that would help.
That would be helpful.
I still think we need to have a little more discussion about how we keep what is developed pristine.
Yeah.
Because we got here because people went into their case management systems. If we're gonna do this, at some point, these should be the only party types, and anything
Agree.
other than these are rejected.
Right, and not to say that they can't be at some point, say a judge says, no, this is an unusual case, it's
Sure.
got A, B, C, D, yeah, that can always change. But it can't be, I don't think it is wise if you have people going outside the traditional party types and just making up stuff like auntie and,
Well, because what will happen is 6 months after these are implemented,
they'll be all over the place.
it will be headed back to where we are today.
I think they just make a request to the standards committee, and it's just up to the standards committee to figure out, is this a unique enough one to add in, or is it a duplicate of something else? Just like we do with case
Yeah.
types.
Yeah.
Right, but that's on the back end. What do we do on the front end to lock it down?
Well, so we'll do it just like the way we do case types in the system. So the clerks they have this set standard of case types that they can submit. Everything else, they have to map on their side, like divorce, like John was saying,
Right,
let's say
yeah.
they have 3 different kinds of divorce. Well, if the standards only have one kind, they have to map those 3 to the one.
Yeah.
So that it would be the same way. They can have 5,000 in their case management
Right.
system if they want to, but they have to map it to whatever the standards say or the options.
Programmatically, if there's not a party mapped up, it won't, the EFM won't pick it up from the CMS. So even if they go in the CMS and add it directly and it files in the case and pulls it in this EFM, it calls it unknown party type, and it just doesn't display it because it doesn't know what to do with it. So, I mean, that is a way to keep it sort of pristine.
Yeah.
On the.
Okay,
It won't add new ones.
let's go one step further. Let's assume we get the list, we get all that done. It's adopted. How long do we give folks to do the mapping?
It'll take a time to.
Well, yeah, I know,
Yeah.
but once we get to that point, we've got to give the counties, the clerk's office, time to do their mapping and get ready for this.
So depending upon how bad they were of one of the 1,500, will determine how much work they have to do.
Good point.
But we're gonna have to make a recommendation at some point about this becomes effective on. Do we give people 6 months, a
I
year?
would give them a year. That gives them time, because there's a lot of stuff going on, especially with this being an election year. And then next year being legislative year,
Right.
I would at least give them a year.
Well, that's why I want to get all this out on the table now.
Yeah, let's do it because we'll start our new year,
This
yeah.
suggestion, it may be, because we have the CMS roundtables too, this may be something you want to bring up to the CMS vendors, because just in case they have specific parties that drive certain functionalities. So you're saying, well, now I can't select this party type from the dropdown, I can't drive this mechanism in the background.
Yeah, no, we do need to.
Yeah, so I would suggest floating that one too. I can't imagine there's a lot.
The only thing
All that
that's,
criminal.
the only thing coming to my mind is protective order cases and
Sure.
identifying those respondents that shouldn't have access to protected information that are trying to get protected from.
Right. No. Right.
What about if, just like you can have a comment, you have the parties And then there's also a comment there where you can add the aunts and all of that, and it's only specific to that particular case. I'm having problems understanding why it has to be part of the case management system if it's only unique to one case in Dallas County. Now, why does the rest of the world have to suffer?
No, I
Yeah.
agree. I'm not,
We
which is
agree.
why I
Oh,
think
yeah.
we shave down this 1,800, 50, whatever number this is, let's shave it down
Well,
to.
Justice Simmons, Bob asked about going forward after that. And so, because there are gonna be people, you know, every 4 years, every now and then, there's 75 clerks that leave and 75 new ones coming in. Then they may be doing things because they may not be familiar with the judicial system. They may come from the insurance industry and they're doing what they know because the system allowed. But if they see where that information goes and it's only related to that particular case, then it wouldn't impact anything else.
Right, okay.
But and that's on the going forward, so we don't have to readdress this.
Well, that's what
every
I'm
5
thinking,
years.
is that what we do is, okay, I think we should, the standards committee should be charged with reviewing this every year. Okay, and just checking out, okay, are there something new, something different? What are people experiencing and seeing how it's working like we always do? And, you know, if in fact there's something outside of these 78 party names or whatever we can do, which I just can't imagine, but it could be there. Then we can talk about adding that or whatever. But I think what we need to do is kind of first get a handle on the 1,500 or however many giant ones are out there to try and get that down to really what is necessary or reasonable. And then try and figure out, as in case types or whatever, kind of figure out a way that almost everything will slot into this. But with the idea that there is flexibility and there's got to be a way, if there's something else up, that it can be filed or done and handled. Yes.
Ask a quick question. Of the 1,500 categories or party types that are listed right now, is there overlap with groups that we already have defined as receiving the information? For example, process servers or sheriff's deputies or something who would not, unless they're being sued, they would not be a party to the litigation, but might have information another way.
Bonding companies.
Yeah. Do we know?
Those are definitely party types that are in that 1,500 list. I'm not sure I don't understand the question exactly.
We're talking about using party as a way of defining who gets access to the information.
Yeah.
Who gets to change the,
Do we have other categories where they're already going to receive that information where we can recategorize? You're not a party, but you are a, governmental employee with information necessary for the case or whatever those other subtypes are. That way we could restrict parties on the ones being affected directly with by the outcome of the litigation or of the criminal matter.
Actually.
And not anybody else who just happens to have an interest in the case. The rules of civil procedure don't define party except for the justice court's defined party. I looked in the rules of civil procedure. We don't define parties anywhere else, but we certainly the judges know who the parties are and who they're not. You could define party in that way to restrict it to those people with an interesting outcome of the litigation. Eliminate a lot of this other stuff.
Cynthia?
That's a really good point, because in San Antonio, in the criminal court subcommittee, we've been talking about the fact that bondsmen aren't given notice when bond conditions are modified, and even to the extent sometimes people are given permission to leave the state when the bondsman's still responsible for making sure they appear and having to pay money if they don't appear. And so I think in criminal cases, I don't know that they're a party, but they sure need to know when bond conditions are modified. So we're having discussions about those kinds of things. There's not going to be as many parties as 1,500 in criminal cases, but there's going to be more than the obvious folks, I would think.
I can't speak for other CMSs, but I know in our case management system, we have a concept of a party, but then we also have a concept of participant, right? So the bonding company is a participant.
Right.
The
like
process server is a participant, so we can define them differently there, but I don't know what other, and so Cynthia, what you're asking, you can do in our case management system, because you can define for this type participant, send them this notification when it's filed.
I know there's gonna be a lot of ironing the wrinkles out, but going back, there's clerk chatter about aunt. And so it could be that the aunt may have been a participant in a protective order case.
Yeah.
Or the aunt could have been the informant on a child abuse case. And so those are kind of things that people are wondering, what do we do with this information? How do we catalog it? And so I think while we're narrowing down these parties, we start looking at those type of instances and how do we categorize those as participants, but certainly not parties.
Well, I think we gotta go back to the bigger thing. They are a informant. They're not an aunt, right? They're the informant, or I can't remember the other example.
Okay, you don't want the aunt to be.
Right.
And have that
Or they could be,
obvious.
a foster in the system, right?
Right.
So can I ask, if we are using AI to narrow down the 1,500 and put them into the category of 78 plus 3, wouldn't that list of how we have narrowed down the 1,500 then go to the local counties or CMIs or to Tyler? And wouldn't the mapping be easier because we've already categorized and recategorized them? That recategorization is what you're using to remap, right? So the only thing that would be left, it looks like that might cause a difficulty, is the fallout from what recategorizing some of those people would do based on what, what you
Right,
talked
when
about earlier.
like we do something new.
Right, but-
Is different from what
But they don't need to redo the work when we recategorize 6 different ways to say divorce into divorce. Why don't we, once we do that work, just give that to you? And so the remapping ought to be almost done for every county because we've already given you the recategories.
Tyler would not do that, because we don't know what configuration
have to
a
go
particular
from-
customer may have done on the back end. So we may give them a recommendation from you guys that said, hey, here's the 30 different ways defendant was spelled. It's now gonna be this. So check and make sure that that doesn't impact you in any way, but we wouldn't just go make those updates to their.
No, but what I mean is if we give that to every county, like the counties then don't need to go through their list and say, what would this now be?
Oh, yeah. No, I think we give them direction.
Yes.
And I think that's the best thing we can do is like, okay, 1,500, forget it. This is where we're moving. And if we have the enforcement ability to say, not only is this where we're moving and you have a year to kind of figure this out, but after that year, bingo, now you go to file, these are the party types that are in the system and they better just fit in one of those. And
Right.
so you've given them time to
Right.
kind
For
of.
the counties, but we're also giving them
Yeah,
like,
yeah, what we
here are
think
the
where
20
things
ways
should
that you
belong.
spell
Yeah.
sheriff. And now it's all gonna be this, under law enforcement.
Right. So, and then I want to make sure, will the counties benefit from this? I know logically and everywhere else, I think we will benefit from it. I think the counties will benefit from it. But what we often get is pushback when we require any sort of changes because it's all money, right? We're requiring things that may cost them money or time or effort. So, John, I mean, do you think this would be a benefit to these counties?
Absolutely.
Okay.
Understand that I get lots of requests for reports from our case management system, from law schools and all these other agencies. And in some instances, you may be able to get a grant to do some work based on, particularly on the criminal side, criminal case information that they're using for case studies in law schools. And so, and now with artificial intelligence, everybody's wanting you to drill down more into specifics into your case information. But if we don't get this cleaned up, then you're just going to be given an agency or law school trash as opposed to real defined information. And just like I said, when we did this in Dallas County, we went through 4 iterations of data conversion because we had to find out, okay, we didn't realize that this was another instances of meaning divorce as opposed to those other 6 that we ran into. And so you go through this loop and it loops until you've gone through that 1,500 different party types.
Okay.
It's an effort, but I think it's necessary. And it's just locked down going forward.
My guess is they don't know how complicated their system has gotten with some of this being entered the way that it has.
Yeah.
But there will be a struggle with some counties because not all counties have IT departments that has the bandwidth to do this type of work. So
Hence why would they need more time?
yeah.
Yeah, no, I think that would be useful, and I think the counties might, I mean, maybe they could go after some grants or something, these small counties, to get some money to help them with that. So in this process of the party types and everything else, is this now just gonna live under standards, Bob? Or are we going to break out and do the party project as kind of an open, kind of separate project?
I think we need to create a group specifically for this purpose, and I think it needs to be broader than just JCIT. And that's the reason I think we need to set it up as a separate project.
Okay, and so when you say broader than just JCIT, who else would you think about including?
Well, obviously, we've got OCA.
Yes,
We'll need Tyler
yes,
for sure. Our EFSPs have a role in this, as do, I think, in our liaison group, we've got a couple of law firm
oh, yeah,
folks that should at least have the opportunity to be invited. What
yes,
show up is for them. And then I guess the other question is, are we going to extend this to justice courts?
well, let's back
Yes.
up, yeah.
We should, because justice courts were appealed to county courts.
No, I'm asking based on.
Yeah, because that case type will just come floating right on in. There you go, Aunt June is floating right into the case type. There we go. Okay, yeah, now I think probably practically, because of the way the appeal works, probably has to extend to justice courts.
And we may want to reach into some of the counties and get some of their data people. I know OCA works with a group of people within the counties that get down into the weeds. And have worked together on the case management.
Yeah.
Case management system standards, as well as the going into the counties of 1 million population or more for reporting.
Yeah.
By individual courts and case level reporting. So it might be helpful to at least offer the opportunity to those folks to participate.
Who would like to volunteer before you?
I would like to volunteer Hidalgo County.
Yay!
Yes.
And also, if I may, I'm sorry, I raised my hand.
Oh,
but
sorry.
I'm sorry, but what I wanted to ask, you made a comment about money being out there and clerks being able to grab. I'd like to know where those grants are and how we can apply for them. What the restrictions are. I know that TAC is incredibly good about helping us find grants, but if you know any that are out there that will help our clerks be able to make this happen, I would love for the JCIT committee to be able to give the clerks a list to help them. I'm not saying that the JCIT has to write those, fill them out for them, but at least giving them access to a list, I feel would be extremely helpful.
Yeah. No, I get your point. No, that would be helpful. I mean, I have not I don't have exactly a specific grant in mind. I did go back though, and I was kind of looking around just to see, like, can counties get grants for certain things? And there's, depending on, okay, is it the criminal side or whatever, I did see that grants are available sometimes for databases and sometimes for those kind of things. So that's why I kind of went, hey, maybe that's more out there. That might be something that JCIT could kind of check into. It's more or less outside of our bailiwick, but we certainly want to help the counties to be able to move on this, with the least pain possible. So that's a good suggestion. Thank you, Laura. Who else? Let me go back though and continue with figuring out who else wants to be on this. Okay, John Warren.
And
Yeah, that's kind of a given, Tracy.
I'll do it from the justice court perspective.
Okay.
Yes. Is that Jesse?
Is that Jesse?
Yeah.
Yes, sorry.
Perfect.
Justice Simmons, I'm always happy to help.
Oh, great. You're in.
I blame Tina for signing.
Right. If you're not in, right, you're on out. So I would suggest if you want to have an influence this discussion, please feel free to volunteer.
I will volunteer since I
There's a lot of comments.
And I'll help too on the criminal arena.
Oh, thank you, Cynthia. Okay, so that sounds like a really good group.
Chat, and Cynthia Moore has the question in chat.
Okay, what does that question say?
It was when Tyler's talking about participants versus parties, I asked, would the participants get notice of when motions get filed, when hearings get set, when orders get entered, or can they only find those documents when they go to the case and pull up those specific items?
They can get notice, but probably, I mean, it takes configuration and stuff, and I can't confirm if that's happening.
Aren't court dockets public? And aren't the courts required to publish their motion and trial dockets? And if that's the case, that's where they can go to learn.
I can't pull up documents in criminal cases in most courts.
Oh, we'll get to that at,
yeah, I was gonna say
6-8.
And when I am the lawyer of record.
Ooh, where'd you get from?
She's talking there.
Signals.
I should have known.
No surprise here. No surprise here. Cynthia, I feel your pain. I understand. Yeah. Okay. So at least though, if they're labeled participants, then that opens the ability to view the unrestricted documents, correct? So, and then whether they get notice, that's a whole different process, isn't it? Right? Giving, okay, who's going to get notice, and I think more has to be done than just you're a participant in terms of having access. Okay. All right. So we've gone to who wants to lead and kind of manage the group that is now going to be looking at the party situation? Okay, Bob and I are going to talk about that, and so you may get a phone call from me. Please don't hang up, and we'll kind of figure out who we can get to lead that. And it'll be one that I think we probably will get on and need to kind of set up a schedule of regular meetings and stuff. I think probably you all do a good job. Everybody's always done a good job of getting the work done in between our meetings. Okay. Okay, secondly, Laura, I do want to address your grant situation. Just because I started that kind of process just out of curiosity, I'll go ahead and see what I can find just in general. This is not going to be a real deep dive or anything else, but just in general, kind of things that might be out there from even the National Center for Courts or something. Sometimes they have lists. So I'll take on that, that task since I've already kind of looked at that a little bit.
Thank you, Justice Simmons.
Right. Okay, all right, so that is, anybody have any more information, ideas, discussion on parties? And party types?
But before we leave standards, though.
Okay, no, we're still on standards. Keep going, Bob.
Okay. We mentioned this at our last meeting, and I want to reiterate it here. Please, if you have recommendations for updates or changes to the standards, please submit them in writing to Frank, so we can keep track of what's pending and make sure that we understand what the request is, that whoever is making it, what they really want. I think that would help the process, and I think it would help the committee when they deliberate.
Right, and I want to thank Frank because he finally, OCA has set up, and we'll start trying to work on that. Basically, we don't have a good repository for all our documents in terms of what JCIT does. I mean, they're in my files, they're in Bob's files, OCA has some, but I think we set up a separate drive, right, Frank? That's what I saw, where we can now start kind of putting things in, we can post things there, we can start thinking about how to use it so that members can access information there. And that should be helpful to us so that if you're working on a committee, you can kind of communicate with that. And also that way we have a repository, kind of the work that we've done over the years, rather than having to rely on just kind of memories and notes from past time periods. So thank you very much, Frank and OCA, for setting that up. And we'll send out an email kind of telling you more. Make that note to do.
Justice Simmons, why are you making it? As it relates to grants, I just kind of Googled some. There's the U.S. Department of Justice that has grants. Actually, the Office of the Governor has grants.
Good.
So there's.
Yeah,
there's
no, I was
there are
surprised. I was like, oh, that sounds good. Yeah, so those sound good. Thank you, John, for kind of starting that. You can also do your own little investigation, please. And then why don't we get our heads together and you can chat about what we found. So you're on the very small grant committee. All right, now let's continue on with standards. What else?
I think we're done.
All right, so what's up next? Please excuse me, my agenda is somewhere in this computer, but is it?
I think it's.
Oh, there you go. Okay.
Filing.
Oh, good. Okay, let's look at the e-filing then.
So we did meet and we discussed a lot of those party types that we just went over, making the same conclusion that we needed to have standards in order to get those going, so that the notices then from Research Texas can go to the appropriate roles and party types in the case. We also got an update from Tyler that the all-in-one notice, the 1-day notice, was rolled out in late April. So they should have a daily digest now. Attorneys will get just the 1 email a day of all their notices in the case instead of the 50 emails. So that went out late April. So for Research Texas wise, if any orders are uploaded into Research Texas, then the attorneys get that 1 daily digest of their notices.
As it relates to that bundled notice, can you send me the information on that?
I think I have.
Yes.
So
So what is that as?
Well, like an example?
what is that as to time? Okay, so yeah, okay, so orders are entered and then, but you only get a daily digest. Well, orders are entered, it's particularly in Bear County all day long. I mean, it's not just a morning thing or whatever. So when do you capture that and when do they get notice of that?
I think it's at the end of the day, so it would be anything that happened up to the point where we sent it. So then like if notices or acceptance are still happening at 11 p.m. and they've already gotten the daily digest, that would come on the next day.
Yeah, I mean, that's what it's like, are we cutting it off at 5 or, I mean,
I don't think it's 5, but I don't know
I
the
can
exact
think.
time.
yeah, we just let me, I was just curious.
It's a practical matter, orders would be entered by 5 or before 5, so.
You should think.
Could be.
Should.
So it seems like 5 or shortly after
Yeah.
would be.
Usually we do like 7 to 9 range in case there's like error filings have to get kind of pushed through from support.
May I ask, is that an opt-in or is that an automatic, meaning that automatic? Okay.
Those are the mandatory notices sent out from that Supreme Court order.
So from the practicing lawyer perspective, let me just say thank you. Because
That's not.
That's why we mandated it, because we figured.
yeah, because it was between all the regular notice stuff and then that, it's like, okay, I know the reason for this. I was part of that discussion for all of it, including the rule change. And it is a real nice thing to have just the one summary email for the day. And it's just a lot easier to keep up with and not lose track of it.
We are gonna expand that to e-filing notifications too, so that is coming as well.
Oh, really?
Well, okay, that's a different question. So we're gonna get one bundled e-file notice?
You don't have to.
I think for e-filing, they're gonna allow you to opt in. Yeah, so if you want.
Yeah, that makes sense.
That'd be great if you just got somebody.
But it's only applies to everything from the court side, from the county side. Okay. And I'd like to know what the counties need to do for the county.
I don't know if I'm not that nice.
No,
That's what,
not for that.
but we need to know that it's done and it's happening so that we're not also doing, we don't want any redundancies by us. We're going to physically do that if we know that that's gonna take place.
Yeah, as of I mean, it's been happening since the order for you.
Yeah, if you're integrated with Research Texas, that county and that office, that clerk's office automatically has the orders being sent out to the attorneys of the lawsuits.
Orders, or is that orders and other
It's
notices?
orders, filings, docket settings, anything that you're integrating with Research Texas.
Mhm.
If it gets added, then Research Texas sends out that daily digest to the attorneys at the end of the day.
So it's done through Research Texas, not through,
It's done through Research
Okay.
Texas, through the daily digest,
okay.
Oh, cool.
right? If you're not integrated, then it does not send out.
1,000 emails.
Correct.
That's correct.
So if you're not integrated, it
Integrated.
doesn't send it.
So, but I think all counties now should be integrated, right?
There's still a small
There's-
handful,
there's
it's
a
11,
handful. Yeah. Okay.
most are.
Right, so
All the
the
ones.
majority of the counties are already integrated and should already have that daily digest to the attorney of record. So what our committee looked at was all the other parties that Judge Hine brought up, which is like the attorney ad litem, pro se's, and what to do for those. The party types we looked at, and that's why we came up with this discussion today. And as far as pro se goes, Tyler did give us an update that they are working on a pro se notification. Am I correct on that? So that they can get those, or am I not correct on that one? I think that's what I wrote. You were gonna match, you're working on a way to take that pro se email and match it with the Research Texas login, and if it matches, they can view and download their cases
Yes, that's.
with no fee.
Yes.
And does that include notification, or is that totally separate?
Yeah, that does not include any notifications.
Okay, so I know the clerks around the state of Texas is really wanting that as well. I said recommendation for Tyler to add pro se party types with emails from the CMS to also send out notices along with attorneys, as long as we can get that direction from this committee, right?
Okay, yeah, so tell me on the pro se, the difficulty, it's always difficult, I think, sometimes with pro ses, but what are some of the challenges that Benny, that Tyler would have in doing this kind of notification?
I can't think of any. I mean, it will go back to the change that we talked about making where we're matching the email of the party to the email in the CMS. As long as that's there, I don't know.
So what would help, once that's done, then the clerks wouldn't have to send out their snail mail postcard or any potential things that they're doing back through e-filing to send out to the pro se or snail mail letter, whichever the case may be. If that notification is then set up with Research Texas, then they can stop that process at the clerk side. So if we get that done, then the clerks can have one less task to do.
How are Rule 306A notices of judgment sent out currently? Are they now electronically sent out, or do we still use a postcard for 306A?
No, if it's the attorney of record, it's being sent out through Research Texas.
But it's an image of the postcard, I believe.
An image of a postcard?
Well,
Yeah.
like the Supreme Court of Texas does,
Okay, yeah.
I remember, I think that's correct. It looks the same as the postcard.
The Research Texas notification is stating the case. It has a lot more information in it. It says what document is being uploaded. Now, depending on the integration with that county, depends on what information is on that line, but whatever they upload to Research Texas saying that this is a judgment, that's what's on the notification from the examples that I saw.
I think right now, to answer, go back to your
Yeah.
question, right now, the order that is requiring the notices to come from research, it only requires it for the attorney.
Yeah.
So I think we need an update there. And the Tyler, I mean, our research system does not do this yet, so it would require some development work too.
But right now, it's limited to the attorney. If it is a party representing themselves, it doesn't automatically.
It doesn't automatic. Now they can go get the document, but it doesn't automatically notify them the same way.
Okay.
That's for the attorney.
Okay. And the thing is, if the party is represented by an attorney, that's what you want. I mean, the attorney probably doesn't want these notices going to the client, then getting it before they do maybe or something. So we need to think on that a little bit.
That's why we're saying only if
Yeah.
they've been flagged in the system as a pro se. So they
Okay.
don't have anybody representing them, then we would like those notices to be sent out to the ones that are flagged as pro se.
So if we do give pro ses the notices, then there will be moments like I can imagine in either criminal law or family law especially, where someone goes in and out of being pro se, right? Like they fire lawyers, they get new lawyers, et cetera, et cetera. There's that time period. So inside of our CMS, we would just have to click
As soon as you change those parties and update them in your CMS, then those are supposed to get sent, as long as you're integrated, get sent up to Research Texas. And the way the APIs work between the CMSs and Tyler's Research Texas is whatever you send them, they're gonna delete everything that they have in there and then place what you put in there. So if you say this person's no longer a pro se, they're being represented by this attorney, that's whatever was in there before gets removed and then that gets placed in there.
And the attorney gets placed in there, is that right?
Right.
So
And then the same thing reverse, if you take the attorney off and now they're pro se, it'll get changed.
What about those instances, because in criminal law, you have instances where someone is pro se, but there is an attorney that has been appointed to them as a standby attorney. So, someone wants to go to trial as a district judge. I would never just say, since you've done all the click boxes to say that you are, that's it. I always give them a standby attorney. So their status is a little bit different.
Depends on how it's entered in the CMS. If the clerks go in and add that as an attorney on that party, then we would assume that's the attorney. We don't have like a concept of a standby. If they just add like a docketing entry that says, if this goes to trial, this would be the attorney, that would not.
Would that
impact it.
attorney be able to be under a participant instead of attorney of record? Because they're not an attorney of record. This person is pro se.
What is this, but then what is a standby attorney? You mean someone who is like a guardian, I mean, more or less a guardian or something?
No, it's someone that advises the client as they go through and provides advice so that all
If they
hell
want it.
break loose in the courtroom, quite frankly, so things can kind of proceed, because pro se's have no idea how to conduct a trial. And especially when they're testifying themselves and examining themselves, it gets really wild. And so standby counsel really kind of helps the train kind of stay on the tracks.
Yeah, no, I can see how it's very beneficial, but tell me what their legal obligation is to that client.
Their legal obligation is to show up during the hearings, especially if there's going to be a trial. They are not the attorney of record. So for bar purposes, like, grievance doesn't go in, and if it does, it would be automatically dismissed because they are not the attorney of record. This person is pro se. But for all intents and
They're
purposes,
entitled to represent themselves, Judge, and so they have to, be able to do everything themselves, really, but standby just kind of helps.
Yeah, no, I'm just from a legal standpoint trying to understand.
You have no obligation.
You're giving legal advice to a client, even if you're quote standby. I mean, I'm just not familiar. It's just a curiosity thing. So
No, I know, but
necessity.
You don't have an obligation to give legal advice either. You're just sort of standing by if they want to ask you something. It's a very difficult role to fill for the very reasons we're discussing right now.
Yeah, no, I imagine the courtroom gets cleared pretty fast and it looks like this is about to be in the appointment process.
Yes.
No, and I know that it goes on. And so just was curious just from at the law review level, right? That's what I'm, curious in that level, not the practicality, because I recognize and have seen the absolute need for that. So, yeah. And I've done it myself when I was on the district court bench. So there you go. But yeah. Okay.
And I apologize for interrupting, Your Honor.
Thank you. Thank you. You are certainly an expert in the field, so we appreciate it.
So it would have to be something that would have to be looked at as far as that particular party type, or flagging that,
or giving it a different name than an attorney.
That's why I was wondering, participant, if we're categorizing, if we have that participant level, that might be helpful.
Yeah.
No, well, I don't want to get an attorney confused with a mother or just a regular participant party in the case.
It's a whole different deal. So I don't think, given what Tyler described, Tracy, I don't think participant would work in this case, because that attorney needs to know everything that's going on, but they have no obligations. It's a bizarre position to be in.
It would probably need to be some sort of attorney party type recognition with a bar number associated with it, so that you knew it wouldn't be attached to that particular pro se, but they would still be attached as an attorney to where they could still get notices and know that a hearing's about to happen or a trial's about to happen.
But in the CMI.
But not replace the pro se.
Exactly.
Yeah, so I'm worried about labeling it attorney or what, you know what I mean? Because that needs to be saved for retained attorneys rather than this particular role. So this is interesting.
Might be one of those 78 party types.
Yeah.
That might be number 79.
Maybe like amicus in a family law case. So, maybe it's that.
Yeah.
Right.
Yeah. Maybe more of an amicus thing might be a better suit. Okay, well, that's very interesting. Who wants to take on kind of the thought process of really figuring out how to make sure for those attorneys that are these standby attorneys, is there a nomenclature we could use that would not confuse the system? Really kind of where we are.
I mean, they could be called standby counsel. because that's what they're called under the law.
Okay, and so counsel isn't automatically converted to attorney or anything else in the Tyler system that you don't need to know? Okay, yeah, that might be a good start. So let's think about that. Tyler, think about that, the terminology, counsel, standby counsel.
Well, is this is specific to criminal? Is that a true statement?
It's specific to criminal.
That's right, and they're not truly like amicus because they don't have any obligation to the court either. But it does serve the court. It's just they're there to stand by. And quite frankly, sometimes we see in this FRERETA representation, which is the right to represent yourself in a criminal
Yes.
case under the FRERETA case, sometimes standby counsel do become
They did.
the attorney because the client figures out, oh, this is what much for me. Judge, I want to give up my FRERETA rights and let my standby step in and be my court appointed. And so sometimes their character changes in the middle of the process because the client figures out it's way too much for them to handle.
We'll get, the reason I asked if it was specific to criminals, we'll get to that discussion.
It could
shortly.
be family too.
Oh, okay.
There's a bunch of proceeds in family.
And you have the concept of a standby attorney for family?
I don't know if we name it that. I have to check with my. folks.
There's amicus and there's ad litem. And
Might be, it's like an ad litem or something, because I don't remember standby counsel in the statutes or anything for family
We might
law.
call it an attorney.
Okay.
Can you see this is a party or?
It's a different party type.
Well, and I think this, we already are having the discussion about ad litem, so I think this should
It'll be
probably.
something similar.
Yeah, but when we get to talking about criminal, we're not sending out notifications on criminal, we're only sending
Correct.
notifications on non-crim stuff. So we're
Okay.
going to get to that point shortly, today to talk about it. So we need to keep this in mind for that discussion.
Okay, so, all right, so let's kind of move along.
Yeah. that was
Yeah,
Subcommittee.
very good. Okay, so
Justice,
when the
the JP,
the JP courts, do we have any update?
see on remote.
He is on there.
Judge Ridgway, you have any sort of updates or anything? Okay, we can come back to you. Let's look at the program updates. To do that, to the person.
I sent him a request to unmute. I can't force it.
Oh, there.
Here we go.
Can you hear me?
Okay, yes, we can now.
Okay, so Jess Griffith is, I think, has a presentation. It's a very brief, about 6 slides. And then I've got a couple comments I want to make after that, that presentation. So I'm going to turn it over to Jess if she has it ready to go.
Well, actually, I don't have it. I guess there were technical difficulties last night. I was unable to receive all the information.
Oh,
Yes.
okay.
We can just put this, we'll just put it on the next meeting agenda. We're happy to do that.
Well, let me go to the secondary point. Well, I can go through some of the points that were going to be made on that presentation. We have more counties participating, and we have greater participation in a number of counties. We've identified 3 partial counties that are of large population. The 9th largest, the 14th, and the 17th largest counties in Texas that are not e-filing yet, or they're making progress, but they're not 100%. I also found in looking through Tyler information that we had one county that was, it looked like it was 100%, but now out of 10 JP courts, there's 8 that are e-filing and 2 that are not. and it's the second largest county in the state. So I don't know what to do with that piece. We identified 3 counties that are partial filing. They're large. They're making progress. We've identified 5 counties of size that are in the top 80 some percent. 5 counties that are not e-filing at all, and that's in our report. The second, so I'm going through what's in the email or in our PowerPoint that we didn't get through. We have created standardized questions to ask, but we have only recently got to the point where we're ready to go make these phone calls. We don't know what the response rate will be or whether we can talk to the right people to answer some of these questions, but it is contact information that we were given by OCA. So hopefully we have good enough information to go. So that's that part. The next piece I wanted to talk about was whether we mandate e-filing across all justice courts. And what I can see, it looks like we've got about 60 plus counties that are participating, and it appears there's somewhere around 180 to 185 counties that are not participating, and mainly because they don't have computers.
Oh.
So if you were to mandate e-filing by attorneys in those counties, but they don't have a computer, I don't know how they're going to be able to respond.
Okay.
So that was another point. I wanted to go through the 4 points that we were going to address in our interviews, and then I want to talk about mandating. The 4 issues we wanted to look at was commissioner court budgeting issues, or personnel shortage, or needs, or insufficient staffing. That's 1. 2, confidence in implementing something new or different. 3 is, are they currently working with an e-filing service provider? We found several counties, and we didn't include them in our list. If they're making progress, but they're not there yet, we didn't address that, but we want to talk to those counties anyway. And then finally, any other concerns that weren't addressed. And so we have standardized questions that we want to go through. Okay, so here was the bigger point. Mandating e-filing for all attorney represented cases. And so I want to go through the various types of cases that, and what we see, at least in some large courts. And I guess I'll have a bias toward Harris County because we're the biggest, but it doesn't necessarily have to be us. So in civil cases, most of them are going to be CPRC Rule 500 through 510 cases. Of those, the debt cases are the most frequently filed in Harris County. If there are credit card payment defaults, it's mostly large firms and mostly are already e-filed. There are store credit card cases. Some, but not all, are filed by law firms. So some of them aren't attorneys filing those cases. The second largest type of cases are evictions. Evictions fall in a number of different categories. The ones that are for non-payment of rent, it's large apartment complexes. Some of them use large law firms, and they mostly e-file. There are some large apartment complexes, but they have only very small attorney, 1 or 2 firm attorneys representing their e-files. Some of those are e-filed, some are not. If it's evictions for reasons other than non-payment of rent, like criminal activity, drugs, unauthorized occupants, landlord threats, parking violations. Most of these are filed by small law firms, and some are e-filing and some are not. The third category is small claims. And if it's an auto accident type of case, those are usually filed by small or specialty law firms. If it's personal injury, it's a mix of large and small law firms. If it's medical malpractice, it's usually small law firms and mostly not e-filed. And these are against doctors, veterinarians, and dentists, mainly in those categories.
In the justice.
Other kinds of cases, contract disputes like poor performance or incomplete work, abandonments, property damage, all that kind of thing. Those are typically pro se filings. If it's a non-title dispute, like a sold vehicle but not by the owner, sometimes those are filed by attorneys and sometimes not. And then there's incident type cases like dog attacks, property line disputes, personal injury, etc. This is a mix of small or solo law practice, and they're not e-filed. So on the criminal side, these are all Class C misdemeanors, things like speeding, no proof of financial responsibility, running a red light, dangerous dogs and like. If they're requesting a trial, a bench or a jury trial, they're usually represented by an attorney. Most of those attorneys are in small law firms, but it's a high volume of cases. Pre-trial cases, some attorneys, some are pro se. Attorneys file, the pro ses do not e-file. There's more research needed on the volume of e-file for the volume of these cases. I wanted to note that precincts 4 and 5 in Harris County are the largest precincts in the state. There's only 3 other counties in the state that have a population that's greater than the population of either precinct 4 or precinct 5 in Harris County. And that's using population statistics from last year.
Hey, Judge Ridgway, this is Rebecca. So we need to, we are late more because I had some issues getting to the meeting on time. It's my fault, I understand, but we've got to kind of press ahead because we haven't even had the presentation on Research Texas and some of our other things that we have to get to. Do you mind because it would be better, frankly, for me, I'm getting a lot of data, I'm trying to type it all in, but I'd love to see at our next meeting, a presentation like a PowerPoint that contains this data. So we can basically put it, where we can have it as a resource and put it in our new, shared drive that we're going to have so that we could use that. Do you mind? Is that okay?
Yeah, I just gave you everything I've got, but if you want those in PowerPoint presentation form, we can simplify it, but I'll make it substantially longer than what we've done in the past.
Yeah, either do that or create a report that just contains it that you can circulate so people can review it ahead of time and then do it that way. That would probably be best if it's a lot of information.
That's fine. We can do that through Frank, I guess, in OCA.
Yeah. That would be helpful. Okay, so Frank, thank you, Judge Ridgway. Thank you very much for your partial presentation, and we look forward actually to seeing it done. And it's amazing the amount of work you've done. So we're very appreciative. You've done a lot of ground level work, and that is just great. We're going to move on now to basically some of the other committee updates. I didn't see where we are. Okay. Research Texas, JCA. Do we want to talk about that real quickly?
So we were thinking that we would probably let Stephen kind of majority of times, I think this is gonna be a more valuable discussion with the JCIT research, kind of spawning into criminal,
Okay,
and then the program updates.
that'd be great. Yeah, thank you so much.
I could talk really fast, but
Yeah. No, well, it's my fault I was late, so.
Yeah, so I'll jump into the research and JCA updates. For those who don't know me, I'm Steven Staling with Tyler Technologies. I've been with Tyler now for over 23 years, focused on the county clerk, county district and justice courts in Texas. So now I work on our sales team and I oversee our sales for the state of Texas. So I wanted to, and Frank, I guess I'll just have you navigate through front slides. There's not many here, but just starting here, I wanted you all to know that historically, Tyler has provided public access to our clients, our enterprise justice case manager clients, at no cost. So we have a couple flavors out in the field, but each of those have been considered end of life or end of support, which has put our clients in a position to decide how are they going to handle public access in the future. So the next slide here is really saying that, one more slide.
Sorry.
All good. And I might be able to use, we'll just keep doing this. One back. But the point is that we have, I got them out of order. So let me see if I can control it here.
You can't,
Okay.
I don't think.
But it's mostly around security. Our latest platform is Research Texas. Research Texas is our public access platform. And the reason being on that prior slide was just the robust security that comes with it. It has data harvesting, robot detection, auto account disabling if you see suspicious activity. So there's a lot of security that comes with our latest public access platform. The key with Research Texas, though, you all, and the purpose of it is a statewide public access platform for all the documents across the state of Texas. However, the configuration is set up based on the JCIT rules, right? So whatever case types or document types you will allow, that is all that is displayed there. So our clients need to display more information because, like, for example, criminal doesn't have all the documents on the case. So it's not a complete record. So the clerks are still having to provide a public view of the complete criminal record through their own public access site. So we'll advance from here. And so, so we created Justice Case Access is something that you will hear. And it's really the same thing as Research Texas. It's just a separate copy of Research Texas that allows local court configuration. Right? So it allows them to control what cases are displayed, what documents are displayed. They can even control the pricing. Whereas Research Texas has a very set price, there are clerks out there that want to be able to provide those documents at no cost to the public or to attorneys. So whether you're the attorney on the case or not, there's clerks that are saying, hey, if you're a member of the state bar, I will provide you access to our case documents for free, no cost. So that's why we created Justice Case Access, is essentially that they need a platform that allows them to do custom configuration and display a more complete case record than what is allowed right now on Research Texas. So we can advance one more slide, and this is really the last slide to compare the two. It really is the exact same platform. It's just Research Texas is controlled by the JCIT standards, whereas the clerks want more. They need the ability to display more. So what this is doing is it's creating a demand where clients are now purchasing Justice Case Access to provide those documents online. So I wanted you all to have that information today so that you understood, something we hear is, well, why don't they use Research Texas for their public access? Well, I wanted to bring this to your attention to understand why they're not using Research Texas.
So they're not using Research Texas because because they want to pay more for Justice Case Access. What are the reasons why, if it's identical, they're not using Research Texas, but they want to go and pay more money and use Justice Case Access?
Because one example is in Research Texas, you cannot see all the criminal documents on a case. They want to be able to make it available to the public, all the criminal documents on the case. So that's an example. Research Texas, they can't expose all the criminal documents. Justice Case Access, they can.
So is this on, do you mean county by county or court by court, or what are you talking about?
Clerk by clerk in the counties. So district
county
clerks and
clerks
county
district
clerks.
clerks.
So
So of course they could ask us in Research Texas and we could do that, correct? I'm just curious.
yes.
Yeah, okay.
You're asking if, it's the exact same platform. You all could decide, hey, we are going to allow all criminal documents online.
Can I ask, give me an example so that I can wrap my brain around what document would a clerk release on a public portal from a county side, or, you know, from justice case access that so far we have not allowed on JCIT?
So JCIT is only allowed 5 document types for criminal cases: indictment, information, and 3 others that I can't remember.
I gave you a motion and order.
Yeah.
Judgment, sentence, and dismissal.
So.
So for
motion-
example,
motion,
trial motions
orders-
and things like that would not be seen.
That's correct.
Okay, all right.
And that's what the clerk, I mean, Cynthia mentioned, like, she can't even get criminal data on from, Bear. That is not unique to Bear. Right now, I don't think there are any counties in Texas that have criminal turned on in Research Texas.
They've started the process, and then once we hit the roadblock of the documents, they're like, well, this is pointless, and then they just kind of stop. There's one thing that also Justice Case Access allows is there's what we call clerk tools. It allows them to grant access to justice partners, and they can kind of control that dial as they please, versus having to go through support to say, okay, I need this user to get this custom role. Clerks can actually now do that themselves for their local jurisdiction.
For like
Which is
bond companies and other people
right,
like that.
right. Or they can create their own custom rules, their own custom securities.
So
they could become more restrictive than research
Correct.
or wide open as they see fit. Now, there are times in research that we put, the reason the restrictions is either they're legal requirements or others. I'm a little concerned that we're letting we're going to let a third party, no sense, provider working with a county clerk or someone decide what is going to be shown or not shown. The whole purpose really from a policy standpoint is you want the courts and their designated entity, i.e. us, to decide or work on those public access questions that are important statewide. And you can agree or disagree with the amount of access that we've granted, and we are always happy to review and look at that. But I am very concerned about having different access, different counties, different courts, I think utter mayhem and confusion results from that. And it also does not provide the public policy ideals that maybe the courts want to have and weigh in on. That's it. And I am all for serious public access. I want the public to have access. They deserve to have access and know what's going on in the court system. I'm just a little bit concerned about, instead of having more of a unified system, you've got, 258 counties, 254 counties, and then the different clerks and different levels all making all these decisions on this sort of thing.
Yeah.
And it's not because I don't love our clerks, and please understand that. Yes.
I just want to make sure I understood this clearly, though. Is Research Texas operating statewide for all filings? Or if I'm Travis County, can I opt out of providing Research Texas and say I'm only going to provide justice case access?
You cannot opt out of Research Texas.
Okay, so the minimum standard or whatever that JCIT is supposed to oversee, that's being provided statewide to all 254 counties.
That's correct.
And then this is an additional add-on for what they can provide or not provide access to.
That's right. So if I'm searching for a case record in Travis County, I can choose to go to research and look, or I can go to their local public access site and look. And this is, they have a local.
But if those clerks want to take on that risk of liability for releasing that information, I guess they can choose to do that at the county level. Okay.
When I want to make 2 points, just looking at what you said. Number one, we as the the vendor, we don't make a decision on what shows or doesn't show, because we don't have, first of all, we're not attorneys, we don't have rights, it's the customer's data, they tell us what to show and not to show. Also, Tyler doesn't want to use Justice Case Access. We would prefer, the whole idea of what research was intended to do when the original contract was written was to be this holistic statewide solution.
That's right.
And that's what we want. But we also have an obligation to our customers if they need to provide access for documents to be able to provide that. So that's where we are kind of stuck in the middle. And that's actually why we wanted to have this broader conversation here. I think and again, I'm not an attorney, so, but I think there's quite a few criminal documents that are publicly accessible or should be publicly accessible that are not, because we're limited to that 5.
Right, and of course, we can bring that up and make those accessible. We would like to have the same sort of things that the counties want.
Yes.
And we would give them to them free, and the people would have it free. So we could do that. We can offer the same thing as Justice Case Access, but for free, at the same high level of service that you provide either way. So I'm just a little concerned about what's going on here. Dan, you had a question?
Yeah, thank you, Justice Simmons. This is Judge Hine. I echo Justice Simmons' concerns and would amplify them. A lot of thought was put into putting these standards together for what would go in Research Texas. There was a lot of debate over whether to do this at all. And I think the central committee reviewing standards for what should and shouldn't be made accessible has resulted in something that is at least is coherent throughout the state. My concern is if we start doing something like this, then we lose that coherence. We also have the problem of where is this document coming from? What's the official record? The risk of confusion if there's something that was available on one platform but not on the other, and that raising additional ancillary questions. And then finally, I'll raise the issue that I've always had a concern with Research Texas is, as the judge, I want to know who I can throw in jail for releasing a document that wasn't supposed to be released. I'm hearing Tyler say, we're just the middleman here, but they're providing this product. And my experience with governments and so forth is sometimes it's kind of hard to find the person who made the call. Having a centralized system with Research Texas at least narrows the scope and allows there to be accountability for the mistakes rather than pointing to, well, it was over there, we thought it was available over there. So I'll just, as I said, Rebecca, I had the same concerns you have about this. I'd like to know a lot more before I feel like I'd have any comfort with having a parallel system like this. Thank you.
Wait, Bob?
Jamie or Stephen, in research, can I restrict my query to a certain county or group of counties? Or do I get everything?
No, you can restrict.
There's a filter.
You can filter it, restrict it. Okay, thank you.
I want to also just address one thing. Obviously, we are a vendor. We are one of many, every vendor has their own public access solution, which is providing an alternative to research. So I just want to be clear that this is not just a Tyler situation. The other vendors are having to do the same thing so that we can support our customers with what they believe they should be providing to the general public. So I just wanted to make that clear because we're not trying to push Justice Case Access. We just have to deliver a solution to our customers. We have a responsibility to.
Okay, and what responsibility do you have to, I don't know, the state? I'm just curious. Anyway, yes, sorry. Cynthia, I think you had a question or you had something.
That's exactly where I was going, where Judge Hind is and where Tyler is talking. I mean, we're already trying to deal with all these and grapple with all these problems about hoping to help every county become uniform. So when you file, you know if the lead document needs to be attached or a separate document, and all these other things that you run into where filings are being rejected when we knew we could walk into a clerk's office and they had to accept a filing. Now it's gotten so difficult depending on where you are, what time of the day it is, and which clerk is on duty at the front desk in person, let alone electronically. And if we look at that opposite side from a filing standpoint, not just an access to the document standpoint, it's going to encourage even more permutations and combinations instead of a standard process and create even more confusion. And Judge Hind's point is not speculative. It will happen with this parallel system, and what the heck, will the record be? And it's I think fraught with problems. So I just wanted to everyone's making a very good point, but we're already having so much trouble with achieving uniformity and filings being accepted everywhere. And what do you have to do to make sure there are? And I see Mark nodding his head. It's not just in criminal. I think it's in any kind of practice. We're going to get away from uniformity rather than encouraging it. And so I'm going to catch the horse before they get out of the barn on this one.
And Nina, I think you have your hand up.
Yes, Justice Simmons, thank you. Hi, I'm Mena Ramon. I'm the General Counsel with Office of Court Administration. And I just want to say that I feel like there's a little bit of confusion in this discussion. This is not something new. The clerks have always had, or some of them, the ability to provide public access via an internet system in their offices, and many of them have been doing this for years. And then when research came along, we started collecting some information. I think the idea was that eventually clerks wouldn't have to have this system. They've always had a system. This is not new. This does not impact e-file at all because e-filing will still be going through the state system. This was simply certain vendors have always been providing this access to case records. You do it at a portal outside the clerk's office. It still has to be maintained on a platform for it to be made available to the public. These systems are getting old, and I think the idea was that they eventually wouldn't need them because they could do everything through research. But because of the limitations imposed on some of the stuff through research, we need to have this discussion. I think this is sort of the kickoff. Some of the restrictions that JCIT has, it's been more for concern about, are the clerks doing things correctly? And is it going to show even though it shouldn't, et cetera, that I think we need to address separately. But Tyler and the other vendors are simply providing a system to replace what they already have right now. So I just wanted this to be clear. The only thing that's different is it's a different platform that's more modern because Tyler has been able to, and I'm speaking for you all, Tyler, work off of their development for the other products they have throughout the country. So I just wanted to be clear on that.
Yes.
Just a quick question. So from that comment and from one or two of the others, would it be fair to say then that just in case access is intended as a replacement for, just giving the example of Travis County, the Travis County Odyssey portal?
Correct.
Okay. And so research, all the data that justice case access would draw from would all be gathered through the e-filing system. It all would exist and live in Research Texas already.
It comes from their CMS because it's stuff other than stuff that may be filed.
But in integrated, I mean, we're almost to the end on integration now, thankfully, but the filing mechanism, nothing changes on that. The data source is all the same. It's just drawing on a subset of that data source.
Yes.
Okay.
You have just case access, like it's just a giant filter for one specific county in a pool of data.
do the counties pay for their individual Odyssey access systems now?
Historically, we have not charged for our public access sites.
Okay.
This Justice Case Access, we have put a cost to it. So there is a cost if they want to purchase Justice Case Access instead of using the free Research Texas option.
How's it work with Odyssey right now? Those are separately maintained. Like for Travis County, again, I've got a login that allows me access to a very familiar looking site that some other counties have similar or basically the same product. But the counties haven't been paying for that up to now.
The portal, like the one you're doing. That's right. We provided a no cost as part of their case management license. So they're buying our case manager, and this public access comes with it at no cost.
Let me add, when they began, when e-file was mandated in 2014, so that means all the documents that we were getting physical paper of, we are now receiving electronically. I did an assessment in my office. What people are not understanding is that we're no longer maintaining paper records, because that would be, for me, an additional $1 million in cost for me to maintain. So all of my records are electronic records, saying we have to make those records available to the public. I think some time ago I shared when we went live for our criminal courts, our criminal cases several years ago, we went through this rigorous exercise of what's available to the public, what's available to the Bar Association, what's available to the DA, what's available to the public defender, what's available to the sheriff. And all of those things were basically put in categories. So if you're not a member, you have to register if you're a member of the bar, you have to register if you were law enforcement, you have to register if you were the DA or the public defender, so on and so on. And you got certain information. We put it in categories, only what you were allowed to see. That was not public records. What the general public sees is the same thing that we had on the shelf, that limited information. So when you look at Dallas County, the only information that's available to the public is the same information that was available in that paper file that was on the shelf.
Ms. Hinojosa, I've seen her hand raised.
Okay, yes.
Yes, so with all due respect to Mena, this isn't the exact same thing. Our public access in Hidalgo County, if anybody wants documents, they can pull them offline and they're free. And now, Stephen, you're saying that through this new system, through Justice Case Access, they're going to have to pay for them just as if they were going through Research Texas.
No.
And
No, that's not true. Yeah.
I want to correct that. Justice Case Access gives clerks the ability to provide documents for free. We don't set the cost of the documents in Justice Case Access. The clerks get to set the cost in Justice Case Access. So today, the general public has to pay for documents on Research Texas. Clerk Hinojosa wants to provide them for free. Well, you can't do that on Research Texas because it's only free for the party of the case or the attorneys or pro se. Justice Case Access is a solution that clerks can purchase that then they can then expose their documents for free or for a cost. You get to choose. So I just wanted to clarify that one point.
And that is another, so we talked about, besides the fact that we're limited to the criminal elements, there are a couple other things that the clerks like with the Justice Case Access, which is the ability to charge less than what Senate Bill 41 was. That is how we have Research Texas configured, is by Senate Bill 41 standards. So they can charge less than that in Justice Case Access because they can set it up and charge whatever they want or nothing, just like what Stephen and Ms. Hinojosa just said. In addition to that, they, in Justice Case Access, have the ability to sell their documents in bulk, right? So Westlaw type company, Thompson Reuters, comes in and says, hey, we want to buy all of your documents and through Justice Case Access, they can do that and still get paid for those documents. Now, they're only selling the ones that are publicly available. But they have the ability to do that through an electronic means versus having to go print out those records or having to do extra work on the back end. So there's a couple of things that are limiting research being that statewide tool. And that's actually why we wanted to bring this up. Again, I want to be clear. We don't want to support. I mean, we have 90% of the population in Texas using the Tyler CMS. We don't want to support all these Justice Case Access in all these different counties. We want to do Research Texas. That was what it was intended for. But because of some of the concerns from the clerks, and so we're kind of trying to bring up their clerks' concerns.
Right, no, and I understand. And so this is just new to me. I wish we'd had a meeting or you called me beforehand so we could kind of discuss this before it's just surprise. One of the things, so you understand that when we come in and we do our rules, all of them are approved by the Supreme Court.
Correct.
They then become rules that anyone that wants to do access has to abide by. That rulemaking requirements that go through the Supreme Court, those will apply to Justice Case Access. It doesn't matter if the clerk may want to show more. There are rules in place that probably that would prohibit them from showing more. So I just want to make clear to you, it's not just JCIT making rules. Our rules don't count for jack. They get approved by the Supreme Court after our meeting. And that's how they get their enforcement and will apply to anyone dealing with these court records. So I just want to make sure you understand that.
Mm-hmm.
Yes.
And one other thing I was just going to say is we understand from this meeting that there are two places to come from information, but they look very similar. And I'm just throwing this out there. There might be some consumer confusion about your branded product versus Research Texas,
Sure.
where they look online, where they don't know what they're getting. So you may want to take that into account internally with your team.
So has research expanded to John and Jane Q Public having access?
Yeah.
Yeah, registered user.
About 100.
But for criminal cases?
Not yet.
Not yet. That's we just now are working
And I
on
was like,
criminal
okay, we still
cases
have that
again.
kind of-
That is
yeah.
something that is done bit by bit, and the Court of Criminal Appeals has every right to weigh in on any sort of change as far as the access. And that's what this group does.
Right.
So Justice,
So if you'll just wait a minute. So I just want to make sure that what I don't want to have happen, or what concerns me, is you talk about, and then the clerk can do bulk data sales. Well, you know, our group has looked at the bulk data and what the problems are with creating giant bulk data asks in the system. And we've already gone through that process and determined, you know what, in these circumstances, we aren't going to do bulk data. In these circumstances, we are. You know, it's not a big deal. And so I just, again, for uniformity and everything else, it's the Supreme Court that rules on all this. It's not clerk necessarily.
Yeah. Bulk data, when you say bulk data, does that include criminal cases?
Yeah, yes. I mean, I could if that's what the clerk wanted.
Okay, you ought to check with DPS because the legislature, gosh, at least 6, if not more, years ago, created the responsibility of DPS to do the bulk data sales. And the reason was to make sure that if bulk data went out there, that when that record changed, there could be an update.
Well, and that's actually, our system does that. But my question, I guess, is for the clerks that are on the call and the clerks that are in the room, you get public records requests right now for criminal data. Are you deferring them to DPS?
If it was up to me, bulk data should be illegal. Because I get sick and tired of, because what they're basically doing on the criminal side is creating kind of a version of clerk's records, and they are selling them. And so, and bulk data should not be used. It should be only used for internal use and not for sale to the public, which is what they're doing. But also when we get the, what is it? When you're getting your record cleared, the expunctions, when we get those, and so all these notices have to go out. That's one of the reasons why we had to have the legislation where we would maintain that order, because that record was found 3 or 4 years after the expunction, and it should not have been found because some organization maintained that record. Yep.
Well, and that can
So,
happen
but-
if someone walks into your office and gets a paper copy and scans it in and puts it online.
Yeah.
And you don't keep up with who.
Yeah, but nobody really wants to do that heavy lifting when they
Right, true.
So
Yeah.
But for me, like I said, when it comes to the public and for bulk data, the only thing you can get are those images that would be on the paper, that would be in the paper file that's on our shelves.
Right.
So even though Tyler is the one that's bringing us the information on justice case access, it's sort of, this conversation leads me to wonder about what we do, not just about, or our feelings about justice case access, but all the other companies that are doing exactly the same thing. Because it sounds like they are getting around certain rules that have been set up, like the price of certain cost for access to documents, et cetera, that have been set up in Research Texas. So it's not just justice case access. This is about a larger issue.
Well, it's about the official records of the court, basically.
Yes, it's a larger issue.
Right, exactly. And basically, to me, that, then uniformity is another big thing, and that's already been mentioned. So, I mean, it's certainly, like I said, this is a kickoff discussion. And I'm surprised by it. I wasn't ready for it. And so I apologize for sounding a little hot about it, but it's just, I was unaware this was even in the works. And so we need to work closer with Tyler, our vendor, to make sure we understand what is going on and what they see in the future. And I apologize for not really kind of setting up separate meetings, which we'll do now.
Justice Simmons, can we do, as it relates to clerks, because one of the things they say in Texas is that if you've seen one county, you've seen one county.
Yeah.
And that applies to clerk offices also, but it would be great. And I'm sure the Bar Association would appreciate it if that, whatever the standard processes are in Dallas, those are the same thing in Tarrant.
Absolutely, uniformity is important.
If we can start having those conversations, because we'll get people that are kind of like way out in left field as it relates to some of the things that they're doing, not understanding that there are protocols for certain things. So we can kind of start having that discussion so clerks will understand what laws apply to some things. So I didn't know that. Bob, I would like to see that law where if you want bulk data as it relates to criminal information, where you have to go to DPS, because I would blast that all over. Leave it alone. Go to DPS.
Yeah, it was.
Yeah, it's I remember.
So, but I think standardizing things, or should I say, having that uniformity will help for clerks as well, particularly when they're planning for how they're going to manage records.
So is it illegal for clerks to be showing their court documents online?
There are certain documents, it's not illegal to show online. We really are glad they're online. That's a wonderful thing. It's a wonderful thing for the public. Unfortunately, there are laws that restrict the type of information that can be shown online. So although it's not a question of whether they can show online, it is, can they show this particular content online? And there's all kinds of, every year we check the statutes because new ones come into play dealing with the public's privacy. Because when they were filed at the court, there's this whole discussion. People didn't all walk down to the court and go look at it. Well, now you've got 7th graders online looking at your justice case access or Research Texas, and they're going to find out all about the neighbor's divorce. So those documents are more restricted on who can see it. It's viewing privileges, really, who want to see it online if they're not a party or whatever. Generally, we should go for the public needs to see it because they're entitled to it. There's a First Amendment right to see these kinds of things, but there are also privacy issues, and it's a constant balance one way or the other.
That's why I say we went through that very rigorous process of who's allowed to have certain access. And the struggle was more so with the Bar Association wanting to see DA information. The DA said that's work product. The public defender said, well, we need to because we're with the county. Yeah, you're with the county, but you are a private attorney representing the defendant. You can't have the information that the DA has. Nobody can have the sheriff's information. And so we went through all of that process. But one thing, the easiest part for us was as it relates to public access. If it was in the file and you came to the counter, that's what you could see. And that was it.
Well, at the same time, this was an issue we discussed a few years ago because there were certain governmental entities that were involved in litigation over this very issue.
It's true.
And I think part of the discussion we had at the time was, look, we're going to provide standards on this, but in some ways, the counties may have to make their own legal decisions on what they think is constitutionally required. So I think we need to have a bigger discussion on it.
Yeah, oh yeah, I think we do
context
need
of
to
that.
have a bigger discussion. Go ahead.
But like, for example,
Go ahead.
oh, I was gonna say, but define document pricing, SB 41, to me, and I haven't looked at SB 41, I'll be very frank, but it sounds like if there's a defined document pricing SB 41, and the question is if you can just get around that here, there, and everywhere, then it.
No, SB 41 is basically the Senate bill of standardizing the fees across the state of Texas. So it says how much a certified copy is, how much an uncertified copy is, so forth and so on.
Yeah.
Which is what Research Texas goes off of, and I'm sure all the other clerks in the state of Texas go off of. But I think where it changes is what they're talking about with bulk data exports, which has different statutes in the code of what you could charge.
Some clerks don't want to charge, and so they're not charging Senate Bill 41. They want to give away their.
It's not a document. The Senate Bill 41 says, here's what a certified copy is, or here's what a new suit is, and that sort of thing. It doesn't get into the realm of data exports.
No, but it does say you can sell a document $1 a page for the first 10 pages and then 10 cents after that or something like that.
Yeah. Up to a max of $6 or something.
So that's what research follows. But in justice case access and what our clerks are asking for is saying, I don't want to charge them anything.
Then it should be certified. Right,
Yeah,
so
this isn't
uncertified
certified in research.
is 0 to whatever.
But nothing is certified in research, so it sounds like because they're
Research is
charging
copies.
0,
Yeah.
they're charging 0. I'm assuming that the law allows them to charge 0.
I can't remember
No,
the
not in-
exact thing.
No, not in research. And research, the fees and local government code 118 is applied there because they said the money that research sends the money to the local jurisdiction.
Which it does.
Yeah, but what I hear Jamie saying is that some clerks, as it relates to bulk data or
It's not bulk data.
or on the justice access, there.
Yeah, on their justice case access side, they want to give away their documents because they always have, that's what they want to continue to do.
If they're giving away their documents, how are they selling the documents?
Well, because they don't know if they go to their local site, they could get them for free and they're in research, so they're buying them there.
I guess my question though was like, how are they bulk selling them?
Oh, well, because if you go, I think the difference is like if you don't want to bulk try to download go in case by case to get them. So bulk, you're getting all of them. So you would be willing to pay for that? I don't know, because I don't.
There is a ton of bulk data access, and it can be things just research that some doctoral student wants to do on XYZ, and you'll get it, or just major research going across the country, and they'll send bulk data for all kinds of stuff.
Yeah.
But I want
And,
to,
before-
provide 10 cents a page, right?
It's $1 for the first page and then 10 cents.
10 cents for each.
That's what I
mean.
mean.
To the
But
10
then-
pages and then 10 cents everything
Yes,
after.
yes.
So
something
it's
like that.
But there's a
basically
match in
10
there
cents a
too.
page. Unless it's only a 1-page document, then it's $1. But if it's a 12-page document, it's 10 cents a page.
So Senate Bill 41,
$1 for the first and 10 cents for each.
so Senate Bill 41 permissive, meaning that you
think it
can charge
says you
zero.
may charge up to, but again, I don't want to be quoted because I really don't know for sure. We need to look at Senate Bill 41, but I believe that that's what it says, up to.
Well, yeah, but we should take, I mean, there's a lot to digest here, a lot to take a look at. And I'm assuming that the same features in justice case access would be implemented in research, right? They'll have the same identical features for all the way through and continuing in the future.
Oh, yes, yes.
Yes.
So
Yeah, before we leave this, I want to go back to the limited amount of criminal information that's in research. There were those of us who believe we should expose more of the criminal information. The reason that we have those documents listed there is, one, everybody agreed that they were public. Period, end of story. And so we decided to take that as the first step as we work through these other issues. It has always interested me that when we had the discussion about research, clerks and others were saying, you can't put it there because it's criminal information.
And that's the Court of Criminal Appeals, and I'm sorry that Simon is not here because is she on?
There she is.
Yeah,
I'm on.
Okay, so you've been a big proponent of really, being careful about the documents that can be accessible by the public in criminal cases. Go ahead.
And I always will be, because there are constantly mistakes. We're constantly finding stuff that should have been even sealed. We get stuff sent to us that we find out it should be sealed. So taking that extra step, but being careful does not mean it can't happen. And it seems like there is still this broad idea that it's criminal, therefore we can't put it there. Our court is not going to mandate that things go on Research Texas, not right now, but that doesn't mean it's not allowed as long as people follow the rules that exist. So, certainly the obvious stuff, no juror questionnaires, nothing that is prohibited by law. Be careful with your sensitive data, things like that. But clerk's offices can do it if they comply with the rules. I'm just a careful person. I'm always going to be more cautious.
I mean, like, for example, the problem is that you have cases that have like notifications that are part of pretrial and that may fall under notices or something else, but like they're child abuse extraneouses, right?
Mm-hmm.
We're talking about data that the general public should never get.
Right.
And the clerks would then need to be able to like look at a data and categorize it correctly or seal it properly. That's a lot of work on a clerk to make sure that that information is not mishandled one way or the other.
One of the things I didn't bring up, and I really don't mean to make this an even harder conversation, but one of the other things is because of the limitation of criminal, it's been talked about today about notifications around criminal. That is not being done in the system at all.
Yeah.
Only civil or non-criminal, civil, family, probate. So I just wanted to remind you of that, because I said earlier we'd talk about that when we got to this.
Yeah,
So
yeah,
just a reminder.
No, but the flip side is that in justice case access, I would be very leery if I was a clerk of a lot of access being given, because there are lawyers who file these notices of extraneouses, even prosecutors. They're never sealed, right? And unless you have a clerk that truly understands what it is that that document is truly saying, you have a lot of information about children, because those are the top litigated cases on the criminal side that are going out because people aren't looking at what it is. They're just looking at whatever the top line is, and they're not looking at the details that are in these notifications. That is a lot of private information, because a lot of those are extraneouses about your child victim.
From a Tyler perspective, I'm Tiffany Kernett, and I work with the Texas Tyler user group. So all of our users participate in this. And we have really enjoyed the relationship that we have with the OCA. We meet with them every single week. And these mandates that you all recommend as JCIT that are then adopted or by the Supreme Court, we love being able to point back to those, saying these are our guardrails and we want to follow these. For us, research is what we want. That's the easy button for us too, because it is standardized and it is this thing. And then we have the information here from JCIT to point back to the court or to the clerks. So we don't have to become the middlemen. We're
happy
in
to
the
be,
water.
I don't know what there will always be clerks who are just wide open to public access. And then you will have others that are like, whoa, these are my friends and neighbors, and this kind of info should not go out where all the kids got it. And I mean, I can tell you from a small town, you have to be very careful. And so you're going to get a wide variety. What we want to hang on to is uniformity, so that lawyers know and the public know when they can go in, this is the items that get shared with you. And that's why we have standards. So I think this is absolutely something we should discuss. We want a robust research Texas. And if, like I said, if it's as robust as justice case access, I'm not sure exactly why the clerks, if you're saying, well, the clerks want to get out from the restrictions of JCI of us and research, they're not going to, because those are all rules approved by the Supreme Court. That's where they come from. And so you will be bound. Anybody, the courts will be bound just like anyone else in terms of providing that access, because you would be going against the Supreme Court to try and provide access when they've already ruled and ordered that those things won't be shown. So
Justice clerks are not they're wanting to get away from research Texas.
Well, that's what I've heard.
They want to show more.
They're fine with their stuff being on research, but they need the justice case access so that they can show additional information like criminal, or probably criminal is the main thing.
Criminal is the biggest driver. Like someone who's been boots on the ground for the last year plus, it's criminal.
Oh, I bet it is. And that is probably one of your diciest areas to show info.
Right.
Because can you imagine the wrong step and what somebody, no job, no future, it's all in the public. So anyway, so that's why we're very careful, and we have people on this committee who are extremely knowledgeable what the Court of Criminal Appeals will eventually allow and not allow in some extent if they want to go out. But certainly we all, as a public policy, ought to take that step slowly and look at it closely, because that is really something that could harm people if it's the wrong.
Could you give us a list of the documents in criminal that clerks are wanting that do not appear currently in research?
Put that on the clerks, or do you know them?
No.
Like, I'd love to hear from a Xena host of their.
I think we'd want to know from the clerks, out of these 5, what's the outlier?
And I think that should come from us, and we could be happy to kind of maybe let's get together and think about what is it, and do a survey of the clerks and find out.
How long has justice case access been up and going?
It's very new. We actually have one county testing it right now in Texas. It's being used across the country, but in Texas, there's additional features that we needed to add. So the first county is using it, testing it internally right now.
But it hasn't been rolled out to the public yet?
That's correct. It hadn't been rolled out. There's several that have acquired it and they're waiting for it to be installed. But but no one got it live and published in Texas.
What's the county that's testing it?
Denton County.
Denton and McLennan actually as well.
McLennan?
You're kidding. I'm trying to read the tone here. Is there?
No, because they used to be so, and this is from a prior clerk, they were really fought us all the way on all kinds of stuff. And he found, I don't know if y'all remember that way back when.
Yeah,
But McLennan was always this outlier that was like the last to do the e-filing, and that's why there's been a change, obviously, which is welcome, actually, that they have moved ahead.
As Stephen mentioned before, Justice Case Access, its sole purpose was to be a replacement for the portal module. That's it. In Texas, you're in a unique position because this group and how tightly knit it is and how well you're marching towards standardization, it almost renders Justice Case Access useless if we can close the gaps between. In other markets, this is going to be necessary because California, Illinois, others, they're all over the place. So we have to have this. For Texas, we don't want just because we want research. So I think it makes sense for, obviously this is the kickoff discussion. We say, here are the pain points that are driving clerks towards Justice Case Access. If we can close those via policy enhancements to research proper, where we can close those gaps, Justice Case Access is basically rendered useless. And you'll start to see clerks fall off of that because they don't want to maintain two systems.
Right.
Well, and that's why my question earlier, what are what are the documents that are causing the pain points?
It'd be hard to pinpoint exact documents. We have to get from the clerks.
I mean, we provide the tool, the clerks are providing the configuration behind it to say, this is what I want to show. We're not necessarily going in and setting all that up to say.
Okay, so they're setting that up on their end.
Correct. The mechanisms they have are, for the document perspective, is the security level. So there's 3 levels they choose from. One is public, generally available. 2 is confidential, which is just your attorneys and parties on the case can see it. And then 3 is sealed, which only people, judges basically have elevated access to it. So that's their mechanism. So you almost kind of have to think about it from not these specific documents, but what's the security behind those documents?
So is it the architecture that they want a different kind of architecture to?
So the way the standards were architected was we want specific document types. If they're labeled like this, which is possible in research in the way we've got the security architecture, but it would be a beating to maintain because you basically have to create a rule that says only include these, but exclude these 40,000 other codes. And that's an ever evolving list. That's why you kind of have to flip it on its head and say, okay, well, we have to look at the underlying security and examples of sealed document types that you can't be allowed and let the CMS drive those. But again, that's early days, but that's something I think we need to dig into.
So I think probably because we're way over time and people have to leave, and this is an important discussion, I think that we should probably set up, and I'll kind of poll our committee on who wants to be involved in the further discussions with Tyler on research and this Justice Case Access product, and kind of think about that in terms of, so are you, and I just want to make sure I understand. So Justice Case Access is a mirror of research, but it doesn't have the same restrictions as research. Right. So it's wide open?
No.
It's configurable by county.
Correct.
And we can only speak to Justice Case Access. There are a lot of other vendors that are out there doing this now in the marketplace. So we can only speak to Justice Case Access, not
but you have 90% of the e-files?
The population. Well, yeah, but there's also other vendors that buy the data.
Yeah, no, I know they buy the data
and put it on.
Tracy's is a good example. Do y'all put your documents online?
Yes.
So that's it.
But we do charge for the documents. They can view it for free, right? But we charge for anything certified or uncertified.
Right.
Just like per the statute, and I pulled it up, in uncertified documents, electronic copies of the documents are, for each document up to 10 pages is in length is $1. For each part of the page over 10 pages is 10 cents a page. So, and that's per Senate Bill 41. And that's exactly what research charges. That's exactly what we charge, right? But they can bring up the document for free. Yes. But we have a lot of security, a lot of built-in mechanisms on our website that if they're just John Doe public, They only gonna get access to certain documents.
Is
And
it the 5
family
documents?
cases, they do not get access to. They don't even get to see the document. It's all restricted. For certain criminal cases, like Sion was saying, if it's something to do with sexual assault, or there's a lot of statute that says if it's sexual assault or predators, or I forget all of the different case types. If it's any of those, we won't show any of the documents for that case type. But for other regular criminal cases, as long as it's a public case, DWI or drug case or whatever it is, we're gonna show those documents. So we show all of the documents in the criminal case file as long as they're viewable. But there's some bonds that go into, because we had a lot of discussion in this in our county, and people want to sue us. So if it has a personal phone number or it has a personal email address of that person or their relatives, like what ends up in a bond, then we only show the first page of that bond and not the second page, because the second page has a lot of personal identifiers that we're not allowed to show. So we may show the bond, but only page 1 of it, and then anybody else internally can get both pages. So there's a lot of mechanisms built in that. And of course, if the document is data sensitive, marked by the attorney, they, of course, John Doe public cannot see that.
Right. But that's beyond those 5 documents. So y'all are showing more
Correct.
than the JCIT. Okay.
Correct. Now, if the document, like I said, we have a lot of document security. If it's a type of document that we know has personal information in there, like, let's say an affidavit of indigency where they start to talk about their bank accounts and what they make and what they owe and all that stuff, we'll just mark that document as data sensitive and or confidential, and then that's not shown. So there's a lot of built-in mechanisms, but we do provide that website because it shows.
Big counties all do, go online.
Right.
But now the value of what they show and what they have is huge, wide ranging, not.
Correct. But I think for the clerks, it's basically, trying to get that traffic that would have to come in person.
Right.
To get that document.
Yeah.
And to be able to get that document online.
Yeah.
But you've got to be able to put in a lot of security and a lot of bells and whistles. I'm not sure what's in this application. But you've got to be able, we don't even allow that pro se filer to get to these documents or any confidential documents until they give a lot more than just their email address. And we connect them to that case, then they can see the documents that they need to see and that sort of stuff. So we have some personal interaction with that person before we give them access when they come in person to file their documents and that sort of thing. So there's a lot of stuff you can't do electronically that you have to make sure, even with attorneys, when they say they're an attorney, we send it to their e-service email address with a bar, on file with the Texas Bar, and they have to respond from that email and before we give them any kind of attorney access, that sort of thing, so we know who they are. And there's a ton of people out there that try to get documents, they try to get access to stuff, they say that this bar number, I can't tell you how many, they say they're the Supreme Court Justice, bar number 00001. And right?
Severe lack of animation on that.
Chief Justice Blacklock.
Yeah,
See, that's
Chief Justice, and it's like, no, you're not. And so, and we get emails sometimes from them saying, why you keep sending us this email? I'm like, somebody's trying to sign up with your bar number. And so, but we don't give them that access.
Yeah. No, they're very robust counties and things that certainly are on top of their access and that sort of thing. But anyway, my recommendation is we're well over time. I thank you so much for staying. I think we set up kind of some working groups and stuff. I think we need to know more about Tyler, kind of what your plans are, what this justice case access is for research. And basically how the flow of the rulemaking of the Supreme Court will flow over to whatever you decide to do on justice case access. So, with that, who wants to be on that scintillating committee?
Actually, I'll volunteer.
Okay, good.
Yeah.
I want to be on it also, Judge. This is
Okay.
Minna.
Oh, hey, yes, of course, Minna. Mm-hmm.
I would like to to help Justice Simmons. This is Laura.
Yes,
And I would too, Cynthia.
perfect, excellent. Anyone else? Okay, all right. So, and then I'll think of the other people that have left, because there are other people that we may want on here. So my thought is that, I know that, you know, you're in development and working, that we need to move pretty quickly. So, we'll try and set up some meetings. I know it's the summertime, but we'll try and set up some meetings, hopefully just starting with phone calls, and then we can kind of work on that together. Okay. All right.
Before we adjourn, can I just throw out, I know my pro se subcommittee, we didn't get to report today, but I was going to report on one thing that I thought was an interesting observation from Evan's data from April. And that is that in motor vehicle accidents, represented clients are 179% greater than pro se litigants to get their cases filed for correction or returned for correction.
What?
Next time you see a billboard, consider whether you could be doing it better on your own.
Oh my gosh. Okay, that is something, we need to put that as a little thing in the next
Pro
box.
se litigants actually out.
There's been a ruling by a judge out of New York that says that consulting with AI is not covered by the attorney-client privilege, and that, I think that's gonna.
That's in criminal cases only. Criminal
Okay.
only.
And there's also
No,
a decision going the other way.
well, the good thing is, considering that we're dealing with just public documents, and I'm okay, well, AI problems are not that.
Files.
Official adjournment. Yeah.
It was
That's the other. Figured yours was gonna be the more,
And you're welcome.
Please don't do that. Yeah.
Kinda, I'm glad I had your input.
I'm not part of it.
You realize you showed up and got it found yourself.
Yeah. I know, it's more just how I say it than anything else, because, you know, I will